When does the president have to get permission of the United States Congress to use military force?
Well, Senator Kennedy.
This hearing turned into a complete disaster for the nominees. John Kennedy asked what sounded like basic constitutional questions. When can the president use military force? When does rent control become unconstitutional? When can government classify people by race? And the answers? Endless legal jargon. Constant, it depends, responses. And zero straight answers. That's when Kennedy fired back. I have no idea what you just said. And from that moment on, this hearing became absolutely brutal. Let's get into it.
When does the president have to get permission of the United States Congress to use military force?
Well, Senator Kennedy, as I was discussing with Ranking Member Durbin, I do want to be careful about hypotheticals in terms of prejudging.
It's not a hypothetical. I'm asking what the Constitution says. When does the President of the United States have to get permission from Congress to use military force?
Generally, Senator, my understanding is the divisions between Article 1 and Article 2 distinguish between the war powers, which are under Article 1 and require congressional consent. Again, talking in great generalities, whereas other use of force, if I understand your question, are things that are likely committed under Article 2 to the President's commander-in-chief powers.
I have no idea what you just said, Mr. Hendershot. Let's try it again. Tell me when the President has to go to Congress to get permission to use military force.
Senator, I think is when, because the text of the Constitution, Article 1, talks about declarations of war, those would be circumstances where the President would, in a general sense, and use of force that is not war under the commander-in-chief power, I think those are under Article 2 without the consultation of Congress.
Okay. I'm sorry, I don't mean to be rude. I just don't understand what you said. Mr. Jones. Let's suppose the mayor of a city, strike that. Let's suppose the mayor of a city goes to his or her city council and gets a rule freezing rents. You with me?
Yes, Senator.
Freezing all rents.
Yes, Senator.
Forever and a day. Let's make it even more interesting. Reducing rents by 20%, because housing is a problem, right? Cost of housing. Let's suppose to try to help people with housing costs, the city, mayor and council, uses its police power under its state constitution as recognized by the federal constitution. So we're going to lower our rents by 20%. And as a result, because of the cost of insurance and electricity and that sort of thing, about half of the landlords in the city just say, look, we're going to have to default on our mortgage. Constitutionally, can the city do that?
Well, Senator, I think it could depend. I do think the city could have some ability to freeze rents. But I think you would have to look at the
Why isn't that a taking?
Well, it certainly could be a taking. And
when does it become a taking? At what point?
Well, I think it would have to be, you'd have to initially look at the impact, the financial impact on the taking of what could amount to a property.
Let's suppose, that's fair, yes, sir. Let's suppose 40% of the landlords will default on their mortgage. Have you reached the point of a taking or not? And how do you determine when you reach the point of a taking?
Well, again, I think it could depend, but there would have to be a showing that, what the financial impact was, and I think.
Yes, sir, I'm sorry, I don't mean to be rude, we just have so little time. I understand that you have to have a showing. Tell me what the rule is.
Well, I think the rule is if you're taking property without, the government, I should say, taking property for a legitimate government purpose, I think you can only do that by compensating the owner of the property.
So
Generally,
any freeze on rent is a act of eminent domain? Is that
Well,
what you're saying?
not necessarily, Senator. I think in your hypothetical, you were, at least as I understood it, we're talking about a financial impact, not just freezing it at the moment, but then going on down the
Okay.
road.
In the hypothetical I gave you, who's going to win if the landlord sued the city or the landlords?
Well, I think, again, it would depend on the
You're
length.
not going to give me an answer, are you?
Well, I think it could depend. I know that's a very lawyerly answer, Senator. but
Yes,
I
sir, it
think-
is,
I
very
think it
hard.
would depend on.
Judge, let me ask you a question in the few minutes I have. Tell me under what circumstances the state legislature can draft a statute that makes a distinction that classifies people on the basis of race.
Senator, I think, Chair Grasso, may I answer?
Yes, and then we'll go to Senator Goins.
Thank you, Senator. I think the circumstances would depend on the specifics of the United States Supreme Court
I
case
know.
law and
Just give me
the
some
state
examples.
constitution
Just give me
at
some
issue.
examples.
Senator, on the basis of race, I don't think, I think in the United States Supreme Court has held that there should be no classification.
No, they've just said you got to have a compelling reason.
That is true, Senator.
So tell me what would be a compelling reason.
Senator, as we sit here today, I cannot give you a compelling reason.
Okay, I appreciate your honesty. Thanks, Mr.
What made this hearing so tense was the clash between plain English and legal ambiguity. John Kennedy kept asking direct constitutional questions that most Americans would expect future judges and legal officials to answer clearly. But over and over, the responses sounded cautious, technical, and filled with legal qualifiers. Now, to be fair, the law often is complicated. A lot of constitutional questions genuinely depend on specific facts, court precedents, and context. But Kennedy's frustration was about something deeper. If highly educated legal experts can't explain core constitutional principles in a way ordinary Americans understand, then people start losing confidence in the legal system itself. That's why moments like, "I have no idea what you just said," and "that's a very lawyerly answer," hit so hard during the hearing. The exchange over race-based classifications was especially revealing because one nominee ultimately admitted they couldn't think of a compelling reason for government to classify people by race. And that answer probably became the clearest moment in the entire exchange. At the end of the day, this hearing wasn't just about technical law. It was about whether the legal system speaks clearly to the American people, or hides behind complexity when the questions get uncomfortable. Subscribe for more explosive political hearing breakdowns and high-stakes Senate confrontations. Like the video, share it, and drop your opinion in the comments. Was John Kennedy exposing legal nonsense, or oversimplifying complicated constitutional issues?